This case is a perfect example of how quickly things can spiral out of control inside a courtroom. A woman already on probation for injury to an elderly person is back in court, not for a new crime, but for violating the conditions that were supposed to keep her out of prison. Missed check-ins, ignored community service, failure to follow mental health treatment, and even contact with the victim. On paper, this is a probation violation hearing. But what makes this case different is her behavior in court. Instead of taking responsibility or showing effort, what you're about to see is constant interruptions, denial, and a refusal to accept help that was clearly offered to her. And in a courtroom, that matters a lot, because judges don't just look at what you did, they look at how you respond when you're given a second chance. So the real question is, was this outcome inevitable, or did she talk her way into a worse situation? Stay with me, because by the end of this hearing, the judge reaches a decision that could have gone very differently.
All right, ma'am. Are you Devin Atkins? And Miss Atkins is on probation for the third-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes.
Yep, I think I would.
Yeah, Mayor Cole, Ms. Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
So, would you please state your full name for the record?
Chicky the boat.
Are you employed?
I'm employed at Johnson County Adult Probation.
And as a adult probation officer, is it your responsibility to supervise an individual on probation by the name of Devin Atkins?
Yes.
So you see Ms. Atkins in the courtroom here today.
Yes.
Can you point to your identifier?
Sorry, in Blue Jersey.
Your man of record of Ms. Cole has identified your probationer Devin Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the course law?
Yes.
And each one of those in detail is gone over with them so that they understand everything that you're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake.
She was advised at her intake and at a CPM at the Meltdown Center.
Okay. And describe to the court what a TTM is.
A treatment team.
Okay. So, in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were, in fact, a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
Yes.
And did Ms. Atkins, based on your review of the file,
Let's break down what's happening here, because this is where the case against her becomes very clear. The probation officer is outlining multiple violations: failure to report, failure to complete or properly document community service, and failure to update her address. These are not small technical issues. These are fundamental conditions of probation. In the legal system, probation is essentially a second chance instead of prison. But that second chance comes with strict expectations. If those expectations aren't met, the court has full authority to revoke probation. And here's the key detail. The officer confirms that every single rule was explained to her clearly at intake and during follow-ups. So there's no confusion here. Now ask yourself, if someone is given clear rules and multiple reminders, but still doesn't comply, how long should the court keep giving chances? Because from this moment on, the judge is no longer just listening. She's evaluating credibility.
on your review of the file, failed to do that on multiple dates, including the most likely not limited to November 4th, 2024, November 19th of 24, and was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something come up and you can look in it?
Yes.
And did she do that?
No.
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? I'm ready.
Mhm.
I wonder everyone's.
I was about to. I know. I was about to.
Serve them. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address, and so that you know where she lives?
Yes,
And if she does not do that, is it impossible for you to locate her?
that was correct.
Did she, in fact, immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your APS.
The main thing is her mental health. She refuses to address that. We made appointments for her with.
Now the case takes a deeper turn, and this is where things get more complicated. We're hearing about mental health issues, and this is important. Courts often provide support systems for defendants who need help, appointments, treatment programs, supervision plans, and in this case, those resources were clearly offered. But here's the problem. She didn't attend the appointments. Legally, that shifts everything. When help is offered and refused, it stops being about lack of support and becomes about lack of cooperation. And then there's another serious issue: contact with the victim. That's a direct violation, especially in a case involving harm to a person. So now the judge isn't just looking at missed appointments, she's looking at risk, behavior, and willingness to follow rules. Let me ask you this. If someone refuses both responsibility and help, should the system keep trying to work with them? Because right now, her chances are slipping fast.
It's been on top, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I have a second?
In a minute, Mr. Lewis, do you have any questions?
Well,
Hold on, ma'am. You're going to get an opportunity. Okay. Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated for the entire time?
Yes, sir.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
unless I may ask, Ms. Cole, Judge, and you stated that earlier, Miss Evelyn Thibodeau, I believe that is her grandmother, correct? Yes,
hold on, ma'am.
at some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she had to have contact with Miss Thibodeau for Miss Thibodeau's safety?
Yes.
Any questions about that? About the count? That's count 8 with the contact. Okay. Then at this time, based on the testimony, I am going to find counts 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yeah.
Any additions or corrections to that report?
No.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report? So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that phenotype MHMR may have, or any programs that probation deemed appropriate for her. I have had conversations with her, and many meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. You know, she did understand that she had the safety opportunity. It didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation and be able to complete this
I
assessment.
mean, it's hard when
Hold on.
tomorrow's not taking patients.
Well, it sounds like you had appointments that you missed that Miss Cole made for you. What did she go to regular Safe P or special? Hold on.
Especially
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health.
This moment right here is where the entire tone of the hearing shifts. The judge is trying to address the mental health issue directly, something that could actually help the defendant, but instead of engaging with it, she completely rejects it. "I'm not a psychopath." That response is revealing. No one in the courtroom used that term, but she jumps straight to denial. And that tells the judge something very important. She's not willing to even explore the help being offered. In legal terms, this shows a lack of insight and resistance to rehabilitation, two major factors judges consider when deciding whether someone should remain on probation. And here's the reality. Probation only works if the person is willing to cooperate. So ask yourself, if someone refuses evaluation, rejects treatment, and argues every step of the way, can the court realistically trust them outside of custody? Because at this point, the judge is clearly losing patience and confidence.
Mental health help. So Miss Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Miss Cole set for you, at least one. How many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean,
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
That's phenoltop.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for...
It's psychopath. Nobody's saying you're a psychopath, but you have...
It's called past program. I'm not a psychopath.
That's not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your... I'm sorry, Miss Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just run around circles.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as...
I have one more thing to say.
Okay.
She is not giving me the information needed to follow up with those type of things.
Okay. Well, I don't believe you. I don't believe you. Miss Cole would never say, go do something and not tell you where to go or help you get...
This is the breaking point, and you can feel it. The judge has now made something very clear. This isn't just about missed appointments or paperwork anymore. It's about safety, compliance, and accountability. And then comes the warning. Stop talking, or it's going to get worse. That's not just frustration. That's a real legal consequence. In court, interrupting or talking over a judge can actually influence sentencing, especially in situations like this where discretion is involved. But instead of stopping, she continues. And that's the key mistake. Because at this point, the judge isn't just deciding based on the violations. She's reacting to the behavior happening right in front of her. So think about this. How much does courtroom behavior actually impact the outcome? Because in this moment, and it's clearly making things worse.
to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that.
I'm gonna die, so I really have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling, like, she thought, like, I could not get up there.
I'm going to hand you the trial court certification that shows this
I would like to speak to a detective.
This was not an agreement, and so you waived your right to appeal. I need you to sign that with her.
I gave the hospital papers. I gave her everything.
I'm also handing you.
I have the doctor's appointment and everything. That's what
I've got 5 more years that I could add on to that.
Oh, man.
I can give you up to 10.
Yeah.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered against. I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you don't.
I'm the wrong person. I'm Devin Atkins. I don't have a gun.
And just like that, the decision is made. What started as a probation violation hearing ends with a 5-year prison sentence. Not because of a single mistake, but because of a pattern, repeated violations, refusal to follow court-ordered programs, continued contact with the victim, and ultimately, behavior in court that showed no willingness to change. The judge made it clear, this wasn't just about punishment. It was about protecting society and responding to someone who refused to take advantage of the opportunities given to her. And in the end, that combination left the court with very few options. But here's the bigger question. Was this sentence justified? Or could the situation have been handled differently if she had taken things more seriously? If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
I'm required to read that to everyone.
I don't know what you're talking about. I don't have a gun.
Good. Then you don't have to worry about that. Go back with the bailiff.
Thank you.